back to Making the Case. During the last few months, we've seen judges all across the country use the power of the gavel to issue vaccine mandates. In New York, 2 different judges have issued orders, one as a condition of bail and the other as part of a plea deal. And in a case we brought to you last week, an Ohio man was ordered as a condition of his probation to get vaccinated or face jail time. This has prompted skepticism from the legal community about fairness and whether the mandates blur ethical lines. Back with me to unpack this legal issue is BNC's legal contributor, Paul Henderson. All right, Paul, we've seen courts impose vaccine requirements on staff, mandating masks and remote proceedings, right? But vaccines as a condition of bail or probation, how far should courts go to balance public health and civil liberties?
Okay, well, that is a big question. So let me unpack it for you, because there's a lot of issues there. Because we have seen a whole series of rulings and orders that have been challenged that allow mandatory testing and in vaccination. But those are occupational opportunities, and those are codified in state actions. And so we've seen those actions taking place and institutionalized in states like California and New York, which were the first ones to try and codify those rulings. And the challenge, interestingly enough, which took place this summer, took place in Texas, which we've been talking about for a while, from the union from healthcare workers that was allowed to move forward, meaning the mandate for the testing and the vaccination was approved in that state. And so what also coming forward later on this week, we fully expect to see the federal government taking action and approving vaccination and testing. And again, these are employees and employers that we're talking about. And so the EEOC, the Equal Employment Opportunity Commission, has ruled recently that these types of mandates are approved and okay as long as they make some reasonable accommodations for exempted categories, basically as long as there's no violations for workplace discrimination. And the issues in the areas that I think it's most interesting that we're watching are the areas in healthcare, in education, and in public safety. Those are the real areas. But this is an entirely different analysis than what we were talking about last week. And the question that you raised of personal liberties and rulings that are taking place in the criminal law junction. Now, that's a whole separate track and analysis. And the approach to understanding those rulings, which I agree are likely not to be sustained in terms of what those judges are ordering in the criminal context, because you have to balance the authority for the issuing party versus the constitutional rights of the people that are being affected. And we're talking about state court rulings in criminal law, and that's a different analysis than your civil rights for employment and for work.
Well, U.S. District Judge Jed Rakoff of the Southern District of New York is one of the judges who required the vaccine as a condition of probation or bail, actually. And he defended his action, saying his order was a matter of public safety. How do you respond to the argument that what Judge Rakoff did was no different than any other judge who mandates medical treatment for people on probation and bail? I mean, it's not unusual for judges to limit where defendants can go, who they can talk to, what behaviors they can engage in, if they can order a defendant to counseling or to take certain prescribed medications. How are vaccine mandates any different?
Well, that raises 2 really important issues as the answer. And one of them is, what is the definition of public safety that people don't all agree on? And then secondarily, that's related to that is, what is the definition of an emergency, which is what we're in for COVID? I would raise the issue, though, that a lot of this depends on what stage these orders are being ordered at. And because that makes a difference. If we're talking about orders coming from a criminal law judge at arraignment or sentencing or release, you have to unpack what the implications are, because a lot of those purposes are already statutory, and it's those statutory definitions have not contemplated specifically corona. I think the pathway and the gray area where they're most likely to have sustained orders are in areas of like a plea bargain, where it's a shared ruling, not just from the judge, but from the defense attorney and or the prosecutor, so that they are sitting down at a table to negotiate these things. And typically, as you know, a defendant waives away their constitutional rights and protections and accepts an order from the court. And that's an area where I think it's likely to be sustained. But short of balancing those constitutional rights here, I think many of these orders that we're seeing involving criminal law and in other jurisdictions and in other contexts are likely not to be sustained, especially because we've just gotten new information about the FDA finally approving the vaccine. And so orders coming before that approval are actually going to create another argument to be raised challenging those orders.
So I was actually going to ask you about the circumstance in which someone agrees to based on a plea deal, but couldn't that plea deal be looked at as somewhat coercive?
In theory, but aren't any plea deals coercive? Arguably, they could be, but in a case like the criminal law, unless you can prove objectively that the standards or the issues are harmful or useless, I think it's more likely to be sustained because people negotiated them with representation and purposefully and intentionally, knowingly, intelligently, and voluntarily waived their rights to accept whatever those offers are, again, with more than one authority. It's the prosecution, the defense attorney, and the judge all approving those negotiated pleas.
All right, veteran prosecutor and BNC legal contributor Paul Henderson, thanks again for lending your expertise. More Making the Case after this.